Okay, so let's kick off. Welcome everybody to this Commonwealth Lawyers Association workshop on strategic climate litigation opportunities using a Pacific Islands case study. My name's Fiona Ai. I'm the CLA Council member for Samoa, and I'm also the co-convener of the Climate Justice Committee, which is hosting today's workshop. For those of you who don't know the Commonwealth Lawyers Association, we're a professional organisation with lawyers from across the 56 independent countries that are part of the Commonwealth, and we all share common law systems. The organisation promotes rule of law and encourages professional exchanges between members through our projects, conferences, workshops, newsletters, and articles. The Climate Justice Committee was established last year as part of some new initiatives for more member engagement in the organisation. We have been working on a number of projects. Part of these projects is this workshop. We're also looking at other things such as a submission to the International Court of Justice on the advisory opinion on climate change and human rights, and collaborations with other organisations such as UN Habitat and the Commonwealth Architects on urban climate issues. A couple of housekeeping matters before we start. You'll see in the webinar chat that there are some guidelines there about questions. If you could please put questions in the Q&A box rather than in the chat, makes it easier for us to manage the question process. Unfortunately, we can't do live questions as we have over 100 participants with us today. So without further ado, I'd like to introduce our presenter today, Dr. Chris McGrath. Chris is an Australian barrister at the Brisbane Bar. His practice focuses on climate litigation and illegal logging cases. He's currently acting in Papua New Guinea on 2 large cases that are class actions on behalf of thousands of customary landowners who are challenging illegal logging. He's also acted as counsel in numerous large and complex cases against Australian coal mines and their carbon pollution and other environmental impacts. We're glad to have him today with his skills, not only as an environmental lawyer, but also as a lecturer and educator. And he has taught numerous environmental law classes at the University of Queensland and the Australian National University. So please welcome Chris, and handing it over to you, Chris.
Thanks very much, Fee. And I'm just going to share my screen. So on your screen now, Fee, you should have my slides.
Yes, I can see those.
Great. I'm just going to hide the video panel. Thanks, Fee, and welcome everyone. It's a real pleasure to speak to you today on this important topic, strategic climate litigation opportunities, a Pacific case study. I want to thank David Dennison and the CLA in Papua New Guinea and Fiona in Samoa for organising the workshop and really support the CLA's objectives. Welcome also to our very international audience, predominantly from Commonwealth countries. There's 447 people were registered for this workshop as of yesterday from at least 36 countries. And it looks a bit like the world has chickenpox there, but I've put with red dots the countries of origin of all of our participants. And I just put a pie graph together of the places that most people come from. So we have about 100 people registered from Malaysia. Welcome. 66 from Kenya, so welcome. 50 from Australia, and then Tanzania, Papua New Guinea, Uganda, Trinidad and Tobago, and then I've listed the countries down the right-hand side of that slide. So welcome everyone to the workshop. This workshop aims to empower lawyers acting for people harmed by climate change. It uses a case study from the Pacific as a window to explore opportunities for strategic climate litigation with lessons for other jurisdictions, I'd hope. My personal driver for working in climate litigation for the past 20 years started in 2004 during my PhD research. I was looking at laws protecting Australia's Great Barrier Reef, and we had mass coral bleaching events globally in 1998 and 2002, and it was obvious at that point that climate change threatened the survival of coral reefs and also the millions of people who depended on them. I'd grown up in the Great Barrier Reef, and I just decided that I needed to work in this area, and I looked for the tools available to me as a lawyer, which is litigation. And I spent over a decade representing clients fighting large coal mines in Queensland, where I live in Australia. And I've learned that we in Australia are very good at making excuses for not taking action to address our huge contribution to climate change. In 2018, frustrated really with the lack of progress in Australia and at request from the Environmental Defender's Office and the Centre for Environmental Law and Community Rights in Papua New Guinea, I became involved in illegal logging cases in PNG and did the foreign lawyer exams and was admitted to practice in PNG to work on cases for customary landowners who are suffering from illegal logging. And this workshop draws both on lessons from climate litigation globally. So I'll mention a number of times the Uganda case in the Netherlands. It also draws upon my 20 years of experience in strategic climate litigation in Australia and more recent work in PNG against illegal logging. And this picture that you see on the screen was taken in 2018. I took it, it was during a site visit where it was a case about illegal logging, and we stayed on the island that's just in the background there. And the whole island at high tide was no more than 50 centimeters above the high tide mark. And I watched the locals eating fish. Evening meal was basically things that had been caught that day on the reef. And I thought, well, what are they going to eat when climate change destroys their reef? And where will they live when sea level rise floods their island? And that led to looking at climate litigation opportunities for PNG in addition to the work I was doing on logging. And I wrote a paper in 2020, which is the main reference for this workshop. There's a link in the chat to my website where I've uploaded the slides for this workshop, but as well as a link to this paper. It's got more detail of the things that I'll cover, really an overview in this workshop. So in outline, I'm going to start with two propositions about climate litigation, and then I want to focus on exploring a framework for strategic climate litigation. We're going to use a case study of representing customary landowners in the Cataract Islands of Papua New Guinea, seeking remedies for damage due to climate change. Going to ask, well, what is strategic climate litigation and why might our clients pursue it? And then I want to unpack 10 key issues for identifying climate litigation opportunities, including identifying things like the plaintiffs and the defendants, the causes of action, talk briefly about the evidence and procedural issues, and then reach some conclusions and key takeaway points. Then we'll have questions. So as Fee said, put your questions in the Q&A. If we don't get to the questions in the time we've got available, I'm happy to answer any questions you have by email. And also we can arrange follow-up seminars or workshops if there are particular topics that you are interested in pursuing, and we've got a group of people. I'm happy to contribute at any stage, obviously working with others. There's so many people with a great deal of knowledge in climate litigation already. So the starting point for this workshop is two propositions about climate litigation. The first proposition is that liability for climate change is widespread, but largely unrealized. I'm going to repeat that to emphasize it. Liability for climate change is widespread, but largely unrealized. I say that because when we look at common law causes of action and modern environmental and human rights laws, they're wide on their face. If they don't address climate change, a well-known major threat facing human society and the environment, which will cause huge loss of life and property, there is something seriously wrong with them. And we shouldn't assume this is the case. In fact, we should assume the opposite. If we've got a big problem that's causing damage, we expect remedies from the courts. We expect remedies from the common law, from our legislation at a national level. So if we come from the basis that, hey, let's look for the remedies that are available to us, we should expect to find them. In the context where billions of people and trillions of dollars of property are already being impacted by climate change, and these impacts will increase dramatically in the future, these remedies are important now, and they will become increasingly important in the future. Where someone suffers loss, judges strive to find remedies, however imperfect. So we should also trust in our courts. If we're going to a judge with a clear cause of action and clear evidence, seeking a remedy for huge harm that's being done to our clients, then we should rightly expect that the court will look for whatever remedies it can give us. So that's the first proposition. The second proposition is that, well, when considering opportunities for strategic or any future climate litigation, we should move from abstract theories to real and specific case studies, the who, the what, which court, how, all of those sorts of questions. And I draw upon something that our new Chief Justice of the High Court of Australia, Chief Justice Gagler, said in a case, Clubb and Edwards, in 2019. He was talking about why the courts should not consider hypotheticals. He said, legal analysis is then directed only to issues that are real and not imagined. Legal principle is then honed through practical application. Academic abstraction is then curbed by the parameters of a concrete dispute. So for this workshop, the concrete dispute I want to look at is to assume we act for customary landowners in the Cataract Islands in the autonomous region of Bougainville, Papua New Guinea. So the Cataract Islands are about 1,000 kilometres northeast of Port Moresby, the capital of Papua New Guinea, which is shown in this Google Earth image. So if we zoom in on that, Bougainville Island is just to the west of the Cataract Islands. So the Cataract Islands, Cataract is the English name for them. They were named after a British navigator. In the local languages, it's Tulan or Kilanalu Islands. There are 6 or 7. One of the islands was split in half in 1980s. So you could say there's 7 islands in the group. They're on a coral atoll, 86 kilometres northeast of Bougainville. So zooming in on that coral atoll, the islands are no more than 1.5 metres above sea level. The largest island is Han Island. I'm going to zoom in on it. So this is Han Island. You can see a village on the western side of Han Island. And this is a picture of part of the village on Han Island. So you can see the village beneath us. About 2,000 people live on the Cataract Islands. So this is a lovely picture of kids in school in the Cataracts. Land ownership under customary law is matriarchal, so it's passed to the eldest woman in the clan. This is a picture of Ursula Rakova, who has been a campaigner for her clan and her people in Cataract Islands, fighting against both illegal logging and climate change impacts for well over a decade. She's led 200 people relocating to the mainland of Bougainville, and you can read about them on the Cataract Islanders Responding to Climate Change Facebook page. So the Cataract Islands are already impacted by climate change through rising sea levels, causing saltwater intrusion, which has affected drinking water and food security. Future impacts are expected to force further relocations to the mainland in coming decades or century. So it's well recognised that small islands in the Pacific, in the Indian Ocean, and in the Caribbean, across the globe, small islands are increasingly affected by increases in temperature. And there's growing impacts of tropical cyclones, storm surges, droughts, changing precipitation patterns, sea level rise, coral bleaching, and invasive species, all of which are already detectable. And that's a quote from the recent Intergovernmental Panel on Climate Change 6th Assessment Report. So for our workshop, we assume as lawyers in private practice, we represent customary landowners in the Cataract Islands seeking remedies for damage due to climate change. And we're using this as the parameters of a concrete dispute to explore a framework for strategic climate litigation. So that's just a hook then to just talk briefly about what is strategic climate litigation and why might our clients pursue it. So litigation can be thought of as strategic when it aims to achieve a wider beneficial outcome than merely the remedy sought from the court. An example of that, a well-known example, is a government regulator might prosecute partially to deter others from similar conduct. The concept of general deterrence is well known. We often use it in sentencing for criminal offences. So when a court considers its penalty, and part of the reason for setting whatever jail sentence or financial penalties imposed, part of the considerations is typically general deterrence. So you can think of that as a strategic objective of sentencing, but it also can be a strategic litigation for prosecutors. For a private litigant acting in the public interest to protect the environment, such as a conservation group, you might litigate to establish a principle to better protect the environment in other cases. So in addition to winning your own case. So of course, the proceedings must have merit and be legitimate in their own right, so that they're not an abusive process. The wider purpose must be in addition to the underlying legitimacy of the proceedings. So in climate litigation, in my view, the biggest strategic objective right now is making large fossil fuel producers and users liable for the damage they cause. So there's been a lot of litigation in the last decade or two against governments, particularly in government approvals. There's been a huge amount of litigation in the US, but also in Australia. Much less litigation against the polluters themselves, and particularly much less litigation seeking damages from them. So large fossil fuel companies like Shell or BP are going to continue to extract and sell their products and drive climate change, and banks and other financial institutions will lend them money for as long as they're profitable. They are only profitable now because these companies do not have to pay for the harm the pollution from their products causes. So if through litigation we can make them pay for that harm and they're no longer profitable, they're not going to go on. So that's a huge strategic objective for litigation, climate litigation right now. So we act for customary landowners in the Cataract Islands who seek remedies for the damage they're suffering due to climate change, and also want to achieve wider outcomes that help others. So they're interested in opportunities for strategic litigation. And that leads me to the framework that's set out in more detail in the paper that I've given you a link for, but 10 issues for identifying future climate litigation opportunities. I've put them on this slide. Things like who are the potential plaintiffs, who are the potential defendants, what causes of action are available. Now, all of these questions, they're going to be things that any lawyer working in litigation asks every day. I put them together in this way, really to just allow the ideas to be unpacked in a structured way. But let's just work through them. And hopefully what I'm going to try and do is move into some of the issues that you might have to think about if you're advising clients and thinking about in your own jurisdiction, how you might engage in climate litigation to representing a client group. And in thinking about litigation, we need to think from three perspectives, I'd suggest. So one is from our client's perspective. We seek to win, but in doing that, we seek to help the judge to reach the right answer. We're not naive in doing that. We are going to bring a case that we see as legitimate, that's supported by the law and the evidence, and we aim to win. But we also, in thinking about that, we need to think from the judge's perspective. So, and we can assume that there is, often you'll know the judge that you're going to appear before once it's listed, and that might affect how you prepare your case. But if we just take, any judge of a superior court in any country, I think we can assume that they are a smart lawyer. And we could also typically assume that they don't have any background in climate science. So if we're bringing a case based on climate change, we need to frame our case in a way that they can understand it, and we can communicate some complex ideas to them in a simple way that's digestible for them, that they can accept. We also need to be aware of what our opposing lawyers are going to do and how they might try and trip us up. Often acting against big companies, I see lawyers trying to confuse the judge. They'll play any procedural trick to win. So in this sort of litigation, we're going to expect, okay, we're going to try and communicate our case to the judge, But we need to do that in a context where the other side is attacking us, seeking particulars. They're going to try and throw, any sort of issue that confuses the judge, but also distracts the judge from the important issues, and against anything that distracts the judge from finding liability for their client. So we need to think from those three perspectives in approaching the litigation. And I use three ethical principles as a litigation lawyer. To me, our goal as lawyers is to help the court reach the right decision according to law. We should be honest and reasonable, but I've learned through bitter experience that you shouldn't expect your opponent will be. And narrowing and avoiding disputes through negotiation and compromise are important, and we should always pursue them where possible, but sometimes we need to fight and we need the courage and tenacity to do this. So this sort of climate litigation is often something that just won't settle because it is so significant for the defendant. If they're going to accept liability for damage done in one case, then they would see themselves as opening up liability for others to claim against them. So they're going to fight, they're not going to compromise, and it's unlikely that you'll be able to resolve this through negotiation. So we need the courage and tenacity for the fight involved in this litigation. So then turning to the first issue, who are the potential plaintiffs? Who can sue? So I've already outlined the Cataract Islanders as around 2,000 people, including children. About 200 have already relocated to Bougainville. Land ownership under customary law is matriarchal. Now, because they have customary ownership of the islands and the surrounding coral reefs, the damage to the land and surrounding coral reefs is damage to customary ownership rights, which gives standing to sue. We could consider a class action for a wider group of customary landowners. So this is just a quote from a PNG government document saying between 50,000 and 70,000 coastal inhabitants rely on coral reefs for their food, livelihoods, and shelter in PNG. So one question we might have is, well, should we bring the case on behalf of the Cataract Islanders and then on behalf of the wider group in PNG that are impacted by climate change? So in framing our plaintiff group, we could think of two main ways of doing it in the PNG system. One is a representative action, and in PNG, they often will call this first category representative or class action, but I really see it as a representative action where essentially you have to get all the plaintiffs named in the originating process, potentially, some of the named plaintiffs, and then a schedule of maybe several hundred who have given their authority to be represented in the proceedings. So you've got to be able to identify them, name them, get a signed consent from them. So that's one option. Then there's a broader potential for a class action where the named plaintiffs are appointed to represent a class of people where the class cannot be ascertained or cannot be readily ascertained. There's provision for that in the relevant rules, the National Court rules in PNG. It's rarely used. Couple of the cases that I'm acting in for customary landowners at present are really testing the ability to bring class actions. We've sought leave from the court to represent a class in circumstances such as one of the islands where illegal logging has occurred. About 10,000 people are impacted by the logging, and we can't, it's in a remote area. It's just impossible really in practical terms to go and get them all to sign consents. So we've applied for the court for leave to be appointed to represent them all. So those are two options, but and I just mentioned that there can be different approaches in other jurisdictions. So in Tuvalu, for instance, any person who is entitled according to custom to represent any community line or group of natives may sue or be sued on behalf of or represent such a community line or group. So a clan leader or chief could represent their clan. In Tuvalu, don't have that provision in PNG, but we could apply for a class or get people signed up. Here, just for simplicity, let's limit our plaintiffs to the Cataract Islanders who can be identified, give written consent, and be named in the proceedings. So that first group. So about 2,000 people we're going to represent in the proceedings, and we've got a defined geographic area. So that's our plaintiffs, our clients. Issue 2 then is, well, who are the potential defendants and who do we choose if we're going to sue someone? So the potential to sue large corporate groups such as BP across the Commonwealth was significantly enhanced by recent decisions of the UK Supreme Court in relation to parent company liability. So Vedanta Resources and Nudgo, and Okpabi and Royal Dutch Shell, 2 cases involving a parent company registered in London, which had subsidiaries operating in countries in Africa that caused pollution. They were sued in London, and the Supreme Court held that the proceedings could go forward in London. They didn't have to be brought in the countries where the pollution occurred. And those are very significant decisions and really open up the potential to sue the big carbon majors. So companies like BP, based in the UK, or Shell, which is based in the UK and the Netherlands, are in jurisdictions where we can look to sue their parent companies. Some of the big carbon majors are in countries that probably we can't sue in. So the Saudi Aramco in Saudi Arabia, Gazprom in Russia. So there's these big carbon majors. Typically, a corporate group like BP will have, you've got your parent company, but then hundreds of subsidiaries operating various projects around the world. And if we're going to sue these corporate groups, it's a pretty mammoth undertaking. On this graph, I just point out a couple of things about greenhouse accounting. So greenhouse gases are reported in tons of carbon dioxide equivalents. The direct emissions from an activity are called Scope 1 emissions. If you're a company that sells products that, like a coal miner, and you sell coal for someone else to burn, then the emissions from burning the coal aren't directly from your activity, but they're called Scope 3 emissions for your activity because you're providing a product that's then burnt. So petroleum, coal, gas, all of the companies that produce those have significant Scope 3 emissions. And that graph shows different proportions for different big carbon majors. But if we're going to do that, it's a massive undertaking. And I certainly learned that suing big corporations, you can just be overwhelmed. So certainly for a test case, your initial cases, if possible, we're going to try and keep it as simple as possible. So my view is limit any litigation to one corporation and one activity in a jurisdiction where judgment can be enforced, and don't go after multiple or large corporations or corporate group, at least to start with, just because of the complexity of that sort of litigation. And here, to test potential liability, I'm going to choose Australia's largest single direct polluter, which is the operator of a coal-fired power station called Loy Yang A Power Station. And it's located in the south of Australia, in the state of Victoria. Melbourne is a big city in Victoria, the capital of Victoria. And about 160 kilometres east of Melbourne is the Latrobe Valley. And the Latrobe Valley had a lot of brown coal very close to the surface, and a number of massive power stations have been built in it. And brown coal is very inefficient to burn. So there's, in terms of burning coal to generate electricity, brown coal has about 50% water in it. It's much younger than black coal, which has much less water. So brown coal is typically uneconomic to dig up and then export to another country because you're transporting a lot of water. So Australia exports a lot of black coal from Queensland and New South Wales, but in Victoria, where it's predominantly brown coal, what they do is dig it up and then pretty well burn it immediately beside the mine because it's too inefficient to transport it long distances because you're transporting so much water. It's inefficient in the sense that you've got to burn off a huge amount of water before you get any useful energy from the coal. The advantage of it is that there's a lot of it, and it's cheap because you're not really competing with international markets. You can really only use it there. So there's some big power stations. Hazelwood Power Station closed in 2017. Your lawn is still operating. Loy Yang A and B are shown on the right-hand side of that slide, and I'll zoom in on them. So Loy Yang A and B are adjacent to a big open-cut mine supplying them with brown coal. And if I zoom in again, So here's the two power stations, Luyang A on the left and Luyang B on the right. If we look at them from, this is a view across the mine pit. So they have these massive coal excavators, and then they put the coal on a conveyor belt and they take it up to the power stations, and then they pretty well just tip it straight into the furnaces and burn it. So this is a picture of Luyang A power station in the foreground. Luyang B is a bit obscured there in the background. I just emphasize that the white steam that you see coming off those big funnels, that's water vapor. That's not a dangerous greenhouse gas. The dangerous greenhouse gas that's coming out of these power stations is carbon dioxide, as well as some nitrous oxides, but mainly carbon dioxide. It's invisible to the naked eye. It's coming out of the big stacks that you can see there in the middle, but you can't actually see it. So all of those clouds aren't really significant in terms of the emissions coming from this power station. It's the carbon dioxide that's the major greenhouse gas. So Luyang A is Australia's largest single source of direct Scope 1 emissions. It averages about 18.5 million tonnes of carbon pollution each year. Luyang B is pretty big as well. It averages about 10 million tonnes per year. Identifying the corporate entity to sue can be complex. Luyang A power station and its adjacent mine are operated by a subsidiary of a corporate group called AGL. And the subsidiary is AGL Luyang Proprietary Limited. It's changed its names a few times in the last few decades, but that's its current name. And it's operated the mine and the power station since 1997, and it plans to operate them until 2035. So we can access the licenses. So this is, going to be useful in evidence as proving, who we're suing, that they are the company that is responsible for the emissions. So we've got the licenses. AGL, the corporate group, is a massive emitter. Its total emissions are about 40 million tonnes. Big chunk of that is Luyang A's emissions. But again, I come back to, let's keep it as simple as possible, go after a single company. And just to give the emissions a bit of context, if we use data from 2016, the company's direct emissions, this is the operator of Luyang A, its emissions in 2016 were 18.7 million tonnes per year. That was 0.05% of global emissions. So China's emissions were 30%. So the company might say, well, that's just a small proportion, but it's enormous, really, in a global sense, because if it were a country, it would be the 87th largest greenhouse polluter globally. Its emissions are larger than the annual emissions of over 100 countries, including Kenya, which emits about 16 million tonnes, with a population of 53 million people. Its emissions are twice the national emissions of Papua New Guinea, which are about 9 million tonnes, with a population of 9 million people. It's over 10 times the national emissions of Fiji. You can't really see it, but I've graphed, or I've plotted on a graph running along the base of this slide, all of the countries that have lower emissions. So I've got Luyang, the AGL Luyang A Proprietary Limited is shown in red on the left at 18.7 million tonnes. And then the list of countries, over 100 countries have lower emissions than this one company. I mean, I just find it startling, remarkable. And that is very useful for litigation. So we're thinking of a judge and we want to have some clear, compelling arguments to say why we are suing this company. Well, to me, it's really compelling to say to a judge, say in PNG, that this single company has emissions twice the entire nation of Papua New Guinea. Its emissions are greater than 100 nations. Clearly, its emissions are a material contribution to climate change. So that's the sort of argument that I'd be proposing to use. So issue 3, well, what causes of action are available? And I want to unpack a few different topics here. So I want to start with international law, then talk briefly about transnational liability, where damage occurs in a country from actions taken outside it. want to mention material contribution as the touchstone of causation for multiple causes. And then I just want to unpack a couple of causes of action, one based on a constitutional cause of action, PNG, the right to life, and a common law cause of action, a nuisance. And I'll move along briefly. I'm conscious of time. In terms of international legal liability, we can't, the Catterick Islanders can't sue a country like China or Australia for its emissions, and neither really can the national government of Papua New Guinea. There's some important international litigation underway at the moment in ITLOS as well as in the ICJ, but they're not going to be able to compel a payment for loss and damage. In terms of transnational liability, it can be used in different ways, but here I want to use it as a term to distinguish from international litigation as well as from domestic litigation. And when I talk about transnational liability, I'm talking about where liability arises from two legal systems, or it spans two domestic legal systems. So, or private international law, there's, multiple terms for, the field of law that involves transnational issues. And at common law, a person can be liable for an act done outside the territory of a state that has a result inside the territory of a state. And that's exactly the situation here. We've got pollution coming from Australia impacting in Papua New Guinea. So we've got potential transnational liability. Key thing in thinking about climate litigation is thinking, well, there's a lot of different sources of greenhouse emissions. Any defendant is going to say, you can't blame me, everyone else did it. But that argument isn't really a good reflection of the law, because the law is that generally that a person can be liable if they make a material contribution to harm. And so that material contribution is the touchstone for liability from multiple causes. Now, I put in this slide a quote from a High Court of Australia decision, which traced the origin of material contribution to an English case from 1866, which involved a defendant factory was held liable in nuisance for the discharge of pollutants from its factory, which had materially contributed to pollution in a river. And that's significant from a Commonwealth country's perspective, because that's part of our common law. So material contribution is an important principle. And across the Pacific, we have many countries that have common law as a component of their legal systems. Most countries also have a written constitution which incorporates human rights. So if we think about Papua New Guinea, the situation, our clients are in Bougainville. The situation in Bougainville is complicated because a civil war was fought in the 80s, 90s, resulting in Bougainville becoming an autonomous region, still within PNG, but there's been a vote for independence. It has a Bougainville constitution, which is linked to the PNG constitution at present. So under the Bougainville constitution, under section 184, it links to the human rights, the guaranteed rights and freedoms under the PNG constitution in sections 35 and including other protections that I'm not going to go into now due to time, but I'd be looking at for potential causes of action in this case. So the right to life, though, is the most significant one. And I want to unpack that a little bit. I'm really conscious of time. I want to get to questions. The PNG Constitution, national goals and directive principles at the beginning includes protection of the environment. The right to life in section 35 states that no person shall be deprived of his life intentionally except execution of the sentence of a court, etc. So no PNG court has considered yet whether climate change is a breach of a right to life. There's some important decisions of Justice Kantakasi, who's now the Deputy Chief Justice of PNG, which are helpful, but aren't considering Section 35 in the context of climate change yet. The language of Section 35 reflects a number of international conventions. So the UN Declaration of Human Rights in 1948, the European Convention for the Protection of Human Rights, and the International Covenant on Civil and Political Rights. The right to life is stated slightly differently in them to how it's stated in PNG. I mention them, though, because we've had important decisions about the right to life under international frameworks that can be influential for PNG. So there's a famous Ugenda case in the Netherlands, in which the Dutch courts held that the right to life under the European Convention for Human Rights includes environment-related situations that affect or threaten or affect the right to life, such as climate change. And we've also recently had a decision involving Australia called the Torres Strait 8. It was a case before the UN Human Rights Committee. It was decided last year. So just for people who aren't from Australia or PNG, the Torres Strait lies between Papua New Guinea and Australia. And so Torres Strait Islanders took action against Australia, saying Australia was breaching their human rights in relation to climate change. And the UN Human Rights Committee held, in relation to Article 6, which is the right to life, that climate change could impact the right to life. The majority, though, went on to say that in the facts of this case, Australia wasn't breaching the right to life of the Torres Strait Islanders, but the whole committee agreed that the right to life included environment-related issues, and climate change was a threat to the right to life. So cases such as Ugenda and the Torres Strait 8 case can influence the interpretation of the right to life in the PNG Constitution, but also other constitutions that incorporate a right to life. I just mentioned briefly common law causes of action. So private and public nuisance are two well-known causes of action. Where we have impacts that occur so private nuisance where the defendant's conduct interferes with the use and enjoyment of the plaintiff's land. So in this case, we'd say, well, that's clear. But we also have to establish that the conduct of the defendant is unlawful, unwarranted, or unreasonable. And we'd have to deal with issues like the common law defence of statutory authority, which also bring in things like reasonableness. And of course, if we were alleging a breach of a duty of care, then of course we would be talking about reasonableness. So the point that I would make about all of these things is that what is reasonable changes as circumstances change. So what may have been reasonable in 1990 or 2000 for generating electricity and emitting greenhouse gases may be viewed, and I'd suggest will be viewed very differently now, as the knowledge of climate change, its impacts, and the cost of renewable energy have changed dramatically. So there's quite a lot of evidence relating to Liu Yang A that it's uneconomic to start with, even now, but it's increasingly uneconomic against renewables. That's even without factoring in climate change impacts. So if you get to the point where it's just uneconomic and it's being propped up by government subsidies, then you've got a bloody good argument that continuing to emit is unreasonable. A whole range of then defences that the defendant may have are going to fall away. So in summary, can an Australian polluter be liable for damage in PNG and Bougainville? In my view, yes. Just moving to some of the other issues in terms of evidence that's available to establish the causes of action and how should the evidence be presented and framed. So the basics of climate science are simple and well understood, supported by mainstream science and easy to explain. They're also unlikely to be disputed. So things like the greenhouse effect are well understood, and you can explain it simply as like the greenhouse effect warms the earth like a blanket keeps you warm on a cold night. It slows the loss of heat. Facts such as rising greenhouse gases driven by burning fossil fuels are very well documented, unlikely to be disputed. There's a huge amount of information available. You're going to need to run these cases. You'll need experts to marshal this huge amount of evidence into a digestible form for the court. And we also need to deal with some concepts that are difficult to understand for the court. So particularly where consequences spill across space and time. all of us have difficulty dealing with those sorts of consequences. So one of the common errors and misconceptions right now about climate change is that the 1.5 degree and 2 degree mean global temperature rise is seen as small, because we're used to dealing with daily temperature changes, which might be 10 degrees. So when we look at the Paris Agreement and we know that the global community has targets of limiting mean global temperature rises beneath 1.5 or 2 degrees, a lot of people think that that's a small change. The reality is, though, it's a huge change because we're shifting the entire distribution of temperature and therefore increasing extremes in a huge amount. So a small change in the mean has a big change in the extreme. And it's the extremes that are killing us. So recent extreme heat waves reflect what's expected to occur as climate change drives a rise in mean global temperatures. So this is just a image from the 4th of August about the huge heat wave across South America. The recent events in Hawaii reflect where obviously the terrible devastation to the town of Lahaina, leaving over 100 dead. So that was an extreme wildfire, but these are the sorts of events that are expected as climate change drives a rise in mean global temperatures. It's no accident that this extreme occurred in the context of extremely high temperatures across the Pacific. So fueling the hurricane that drove the very high winds, that was a key factor in this catastrophic fire. So extreme events like the exceptionally high ocean temperatures at present are expected to occur as climate change drives a rise in mean global temperatures. So we need to convey this to the judge. Another big thing is that the impacts of the burning of fossil fuels are not short-lived. They're going to be around for millennia. So they're nearly irreversible for 1,000 years. So burning coal at Liu Yang A power station and around the world, the impacts will be felt for a millennia. So in terms of then thinking about limitation periods, that's important because emissions that occurred 20 years ago are still causing damage. So in PNG, they're not outside the limitation period because there's a fresh cause of action arising because the damage is ongoing. So just turning then to remedies, what remedies are available that a court will realistically grant? The PNG Constitution allows claims for things like injunctive relief for breaches of constitutional rights, but also allows for compensation for breaches of constitutional rights. As well, if you're claiming a nuisance, you could claim an injunction or damages under common law. So one of the benefits in seeking only compensation or damages is that instead of trying to have an injunction to shut down the power station, is that getting an injunction involves discretionary factors for a court, whereas in contrast, if you seek damages, a court is much more likely to just grant it if they find that your cause of action is made out, but also you can enforce it. So we can enforce a money order made by a PNG court in Australia. There's issues around damages like, will it be joint, several, whole, proportionate liability? And the short answer to this slide, to what I've written in this slide, is that's a big, ripe question for the case, any litigation. There's no clear answer to that. How do you quantify, though, the damage for people living in traditional lifestyles? This is a question that really troubles me. I don't have a good answer to it. My view is, though, in any litigation like this, we should be seeking exemplary damages linked to the commercial profits for the polluters. So applying case law like this RH case that I've mentioned in this slide, which, in the context of what's occurring, in my view, exemplary damages should be a big component of what we're seeking from the court. And that then would mean a big award of compensation or damages. And I've just given the extract from that case about exemplary damages. I won't dwell on it. So given that the company is making hundreds of millions of dollars from its polluting activities, exemplary damages should be in the order of many millions of dollars. And then just a couple of issues to wrap up before we go to questions. So what court should the litigation be commenced in? In PNG, there's a Superior Court of Record, the National Court of Justice would be the court to sue in. The appellate court in PNG is the Supreme Court of PNG. And in terms of procedural obstacles and how they can be overcome, there'd be 4 stages to this sort of case. You'd apply ex parte in the National Court of Justice for leave to serve the defendant in Australia. You'd then serve the proceedings in Australia. Once it's effected, you then have a trial in PNG and any appeals. And if damages are awarded in PNG, then you enforce it in Australia. We've got reciprocal arrangements with PNG, which are in Australia, we've incorporated them into laws called the Foreign Judgments Act, which allow for essentially a decision of the National Court of Justice in PNG to be registered in Australia and then enforced as if a decision of an Australian court. So you can enforce a damages award. The application for leave, you need to prove that there's a sufficient link to PNG. Here we're saying there's damage within PNG. That's one of the grounds for a link to PNG for leave to serve. So political issues are irrelevant. So what's, the diplomatic relations between PNG and Australia aren't relevant. And in terms of resources, we're going to need resources. It's probably going to run for a few years. There's quite a lot of money around for climate litigation from big funders like Bloomberg. Also, what we'd be looking to do is open this area up for litigation funding. So we want to bring in commercial law firms and commercial litigation funders. So a test case like this hopefully opens the area up for much more litigation by others. Okay, I've given some conclusions and takeaway points. Given the time, we'll just leave those in the slides, and I just want to move to questions. So Fiona, I'll stop sharing my screen and address any questions that might have arisen.
Yeah, thanks, Chris. That was just an incredible amount of information and so practical, giving us so much food for thought about how we could actually take these sorts of proceedings in the Pacific and in other parts of the world. We've got 6 questions in the chat, which we can probably get through in the next 6 minutes before the end of our allotted hour. The first question we had came through was if you think it would be easier and a more strategic objective to stop further emissions through interim relief sort of declarations or injunctions rather than making emitters pay for past emissions.
Well, I probably addressed that in just at the end of that presentation. It's difficult to get injunctive relief, more difficult to get injunctive relief. There's a whole range of discretionary factors that are going to be, like the court is going to have to consider, well, if I order this power station to be shut down, the impact on the people that rely upon it for electricity. Whereas if we're just seeking damages, all we're saying to the court is, well, they can keep polluting. We just want to be compensated for the damage that's occurring, and we want you to remove the commercial benefit to them. It's a much less discretionary decision, and it's also something that we can enforce. So if we get that, if we got an injunction, for instance, from the court in PNG or any other country, we couldn't enforce that under the Foreign Judgments Act. So a purely money order actually has huge benefits. In terms of interim relief, it's always a huge hurdle to climb to get injunctive relief. Typically, you have to prove irreparable harm between when you commence, when you're seeking the injunctive relief and your final relief. So let's say that's 6 months or 12 months in this sort of case. It would be hard to say that in the 12 months continuing emissions is going to be so critical that it can't be compensated in damages. So you wouldn't be able to prove irreparable harm that can't be compensated in damages. One would think, or at least it would be hard. I wouldn't be going for interim orders. I would just be running this fully to trial. You want a good decision from a court that then you have to go through all of the steps to then lay the foundation to be able to file it in Australia and enforce it. So you have, like under the Foreign Judgments Act, for instance, if you haven't properly served or the defendant hasn't been given natural justice or there's some other reason, they can avoid liability. So you need to follow the right process, properly serve them, give them the opportunity to appear. They then have the choice whether they appear in PNG or not, or if you're, litigating in Samoa or Fiji. If they choose not to appear, well, great, you've got a sort of free kick. There's no defendant there. You just present your evidence and call on the court to, grant your relief. And if they appear and, as they're likely to, and they're, you're likely to be showered with, requests for particulars and then a whole heap of sort of interlocutory applications trying to kill the litigation without letting it go to trial and exhaust your resources. But that's just what you've got to be prepared for. So my view is damages is the remedy that I would be going for. I wouldn't be seeking interlocutory relief in this sort of case.
Okay, thanks, Chris. A couple of questions come through from Ben Slade, although I think you've probably answered some of them in your presentation. One of his questions is, why would your instructors not sue Loy Yang in the federal court in Australia, taking a class action, and the company being Australian gives the court jurisdiction?
That's a great question. I'm particularly interested in trying to give two things. We have had some fantastic decisions from some courts in Australia, but our court system at present reflects really the culture in Australia, which is supportive of essentially our fossil fuel sector. So I have particularly looked at the Pacific because I really believe in trying to give autonomy. The Pacific is calling out now. The politicians in Fiji and Vanuatu, so many countries criticizing Australia for not taking action on climate change, and people feel disempowered. So this idea is, the origin was, as I said, standing in an island in PNG and thinking, what's going to happen to these people? And thinking from their perspective, what could I do as a lawyer that can give them a voice, get them into court, let them, sue someone for the harm that is happening to them. And so trying to give those people a voice, allowing them to sue in their own national courts, I just think there is so much power in letting people have the autonomy to bring cases in their own courts for harm that's occurring in their own courts. Also, there was litigation in the federal court, was it in Victorian Supreme Court, I think it was. It involved a big mine called Oktedi in Papua New Guinea, where there was huge pollution to local people, and there was an Australian company involved, and there was a claim brought in Victoria, which failed basically because what the court held that there was a big problem in the fact that the land was in PNG and the court didn't really have jurisdiction over it, and it wasn't an appropriate forum. There was an interlocutory decision. So you wouldn't be able to bring the claim in Australia for harm in PNG or Fiji. You would be about harm in Australia. And I do think that there is potential for big class actions in Australia, where we've got commercial litigation funders. We had in 2020 billions of dollars of damage due to bushfires, clearly driven by climate change. So I think that there are big class actions coming. I just don't think the time is right yet in Australia. But I think the time is right in countries that are being directly impacted now, that have, like PNG, like Fiji, Vanuatu.
Thanks, Chris. We're kind of running out of time here, but I think we've got time for just one more question, and perhaps other questions can be posted and with direct responses. This one came from Samuel Tininodi. He has asked, how do you reconcile environmental litigation and the desire for a society to develop its natural resources?
Well, they're not mutually exclusive is the starting point. So we need jobs, we want a good society, but we don't, a society that destroys itself, destroys the environment around it, doesn't have a long-term future. So we have this amazing world with incredible people, the ingenuity in it, the systems, the things that we do are amazing. we want that to go on. Right now with climate change, we are destroying our future. So we want development. We want our people to be well-fed, live in peace, and succeed. We can't choose those technologies that destroy us. And right now we know that developing fossil fuels, continuing to develop fossil fuels at an enormous scale is killing us and will destroy, the current generations, not just future generations that come after us, but we're already suffering huge damages. The 100 and more people that were just killed in Hawaii, those are deaths that are linked to climate change impacts. There are people dying already. There are huge billions of dollars worth of damages already occurring. Huge amounts of people will be displaced. Wars will be fought. When people are, displaced by sea level rise, they've got to go somewhere. So dealing with this is essential. It's not a, do we do it and starve? We still want to have, we're going to use technology. We're going to use our ingenuity to solve these things.
Thank you. I know we're over time now, but perhaps we've got time for just one more question, which was that's been posted in the Q&A that was also something on my mind, is about how would you approach the issue of causation given the indirect harm caused by climate change? Courts appear to be willing to impose a duty, but are unable to find a causal connection between the breach and the harm suffered.
So that's a great question, and it's going to be one of the things that's live in the litigation. I sort of outlined it in the sort of section on evidence. Concepts like common sense, permeate when we talk about causation. Courts have increasingly rejected things like the but-for test. So common sense, we have a large polluter that emits to the atmosphere. We know that there is one atmosphere so their impacts from their emissions are impacting the whole globe, including our clients in the Cataract Islands. So we say we don't have to show that a molecule that came from the power station causes coral bleaching in 2035 in the Cataract Islands. We can basically lump that all together into the harm that's been caused. It's their cumulative impacts, but as I said, a key test is, do they make a material contribution? And my view is when you look at comparison with the emissions from other from countries, to say that this one company has emissions greater than 100 countries, twice the emissions of PNG. I just, having that argument before a judge in PNG, or let's just say it's in Samoa, or you're in Tuvalu, or you're in Fiji, and you're representing people that are impacted there. You're looking at this foreign corporation that has, you're in PNG, one company, the defendant, has emissions twice the countries. How can the judge not find that's a material contribution? The country, PNG has got legislation about recognizing climate change. It's a signatory and, party to the United Nations Framework Convention on Climate Change. It's involved, it's recognized internationally as PNG being a significant contributor. Here's a single country that is a single company that's twice its. How can it not be a material contributor? So you just have to get over the material contribution hurdle. And ultimately also I would say that that's a question of fact for the judge. So you've got the principle, bring in the evidence about their emissions, and then it's up to the judge to decide. And as I started by saying, we should respect our courts. We've got fantastic judges. We have got, so many Superior Court judges they're brilliant lawyers. They actually want to solve the disputes before them and do justice. You come before them with people that are going to lose everything, and you've got a defendant that is a material contributor to that harm. You lay out the legal pathway, you lay out the evidence that establishes the cause of action. We should expect that our judges will give us a remedy, not shy away from testing these things in our courts, thinking that our judges are going to be too timid to accept the evidence, accept the implications of the findings.
Thank you, Chris. I'm afraid we are well over time now, and I think we're going to have to call it a day, but there's a lot of other questions that have come through that we would be happy to be able to share some written answers that can be shared on the Commonwealth Lawyers website and also on Chris's website, the links to which I've already put into the chat. There is also a link I've posted to a feedback form for this session. If you'd be so kind as participants to complete that, that would give us really helpful feedback about what you found interesting and other issues that you would like to hear about, and activities we could undertake, workshops, and feedback about things that we could do differently next time. Small plug for the Commonwealth Lawyers Association. If you've enjoyed this session and you'd like to support our work, please join us. The membership details, excuse me, are available on the website, again, posted in the chat. We also have an upcoming conference in Borneo, which is co-hosted with the Sabah Law Society in February next year, the Borneo Rainforest Law Conference, which will also be looking a lot of climate justice issues. If you have particular questions that you would like to raise with Chris or with me, or you've got requests for further sessions that you'd like to have done with a particular group, please email them through. I've just posted in the chat there Chris's email and my direct email address. Please contact us, and we look forward to welcoming you again to the next CLA Climate Justice Committee session. Thanks everybody for your time today.